Good afternoon, dear students. The topic of our lecture is consular functions, consular privileges and immunities. So today we will talk about such issues as first, functions of the consulates, second, privileges and immunities of a consular post, and third, privileges and immunities of the members of a consular post. Let's start from the first question, that is consular functions. As you already know, the main document in the sphere of consular relations is the Vienna Convention on Consular Relations of 1963. But in addition to this multilateral convention, states often practice to conclude bilateral consular convention that determines the number of consular posts of the country in each other's territory, location of consular districts, privileges and immunities of consular staff, etc. For instance, Ukraine have a lot of bilateral consular conventions with different states. For example, Consular Convention between Ukraine and the Republic of Turkey of 1999, Consular Convention between Ukraine and the Republic of Moldova of 1996, and other conventions. The source of consular law include also the domestic legislation of the states that regulates consular relations. The legal basis for activity of consular posts of Ukraine is Consular Statute of Ukraine of 1994 that regulates consular functions in more detailed form. Also, it is a current legislation of Ukraine. For example, such decree of the Ministry of Foreign Affairs of Ukraine as regulation on the accreditation of the members of foreign diplomatic and consular missions, international organizations and their staff of 2003. And besides that, the legal basis for activity of consular posts of Ukraine is, of course, international treaties of Ukraine. Though a consul may perform in exceptional cases diplomatic functions, he typically exercises specific functions different from the general duties. In this specific capacity, the consul is the mission's contact person for individual cases. He is his countryman's friend in need and the foreigner's intermediary. Consular work in this specific sense is done in consulates and in consular section of embassies. Article 3, paragraph 2 of the Vienna Convention on Diplomatic Relations of 1961 expressly confirms that consular functions can also be performed by a diplomatic mission. The Vienna Convention on Consular Relations defines the consul, whom it calls a consular officer, only indirectly. A consul is a person who exercises consular function. According to Article 1, paragraph 1, letter D, consular officer means any person, including the head of a consular post, entrusted in that capacity with the exercise of consular functions. The functions of a consul are, however, extremely diverse, because according to a well-known statement by French diplomat Charles-Maurice de Talleyrand, the responsibilities of a consul are endlessly varied. Accordingly, the list of consular functions contained in Article 5 of the Vienna Convention on Consular Relations is a long one and, as can be taken from letter M, not a final one. So the main consular functions are stated in Article 5 of the Vienna Convention on Consular Relations. Among these functions can be highlighted such as protecting in the receiving state the interests of the sending state and of its nationals, both individuals and bodies corporate, within the limits permitted by international law. Furthering the development of commercial, economic, cultural, and scientific relations between the sending state and the receiving state, and otherwise promoting friendly relations between them in accordance with the provisions of the present convention. Ascertaining by all lawful means conditions and developments in the commercial, economic, cultural, and scientific life of the receiving state, reporting thereon to the government of the sending state, and giving information to persons interested. Issuing passports and travel documents to nationals of the sending state, and visas or appropriate documents to persons wishing to travel to the sending state, and a lot of other functions. Article 5 consists of a big list of such functions, but if one tries to reduce the specific consular functions to some common denominators, the following duties stand out. First, it's protecting the interests of the defendant state's nationals, including assisting detained nationals. Second, performing administrative functions, including issuing visas. Third, exercising legal functions, including those linked to the administration of justice. And fourth, taking care of shipping and aviation issues. Thus, a consul in the specific sense of the word is an official agent of the defending country who protects the interests of his country's nationals, performs administrative functions, exercises legal functions, and takes care of shipping issues in the receiving country. Consular institutions have their own history. They developed independent of diplomatic relations. The merger of the diplomatic and consular services that occurred in many countries in the first half of the 20th century blurred the difference between diplomats and consuls. A foreign service officer can once serve as a consul and later as a diplomat and vice versa. If a consular officer serves in an embassy, his status is indistinguishable from that of his colleagues in the embassy who exercise diplomatic functions. According to Article 70, paragraph 4 of the Vienna Convention on Consular Relations, the consular officer within an embassy enjoys diplomatic privileges and immunities. A consul needs a double set of authorizations. He can exercise his functions only if he has an authorization by his country's legal system. He can, for example, only issue a passport or visa, act as a notary, supervise and inspect vessels, or perform a wedding ceremony if municipal law assigns these functions to him. Many countries have codified the main rules and regulations. The municipal consular laws and regulations are the basis provided by the home government for consul's activity. For example, in Ukraine, as I already mentioned, it is a Consular Statute of Ukraine of 1994. Since the consul operates in a foreign country, he also needs an authorization by international law. Over the centuries, bilateral treaties and international practice have been the basis for consular relations. Meanwhile, the Vienna Convention on Consular Relations of 1963 has largely substituted for bilateral agreements. Existing bilateral consular agreements remain in force and new ones can be concluded. Since most states have become parties to the convention, it has become the international recognized standard of consular relations. So let's discuss some specific functions of consuls, which are fixed in Article 5 of the Vienna Convention on Consular Relations. If we summarize all functions by some categories, the first function will be protecting nationals. So, according to letter A and E of Article 5 of the Vienna Convention on Consular Relations, helping and assisting nationals and protecting their interests belong to the consular functions. It is stated that consular functions consist in protecting in the receiving state the interests of the defending state and of its nationals, both individuals and bodies corporate, within the limits permitted by international law, and helping and assisting nationals, both individuals and bodies corporate of the defending state. States make an effort to take care of their nationals who live abroad. A consul can support a compatriot only if he is aware of the fact that the latter is in trouble. Therefore, free communication and free contacts between the consul and his fellow countrymen are a prerequisite for consular activities. Article 36, paragraph 1, letter A guarantees these freedoms. What precisely consuls can do and to what extent they are obliged or have discretionary power to assist their nationals are up to every state to decide. Though consular laws of states differ, similar activities of consuls from different countries can be observed. Consuls give advice to their nationals on how to deal with local authorities. For example, German consuls also advise German nationals on legal questions, particularly on those arising in connection with a move to a foreign country. British consuls, on the contrary, cannot give legal advice. Consulates may provide lists of lawyers and doctors. Only in exceptional cases, when the national is absent or otherwise unable to defend his rights and interests, will the consul represent him or arrange his representation before the tribunals of the host country. Consuls take care of lost property of their nationals and will try to return the articles to their owners. When persons are missing, consuls assist in finding out his or her whereabouts. It is a particular challenge for consuls to assist nationals who are in difficulties or distress. It happens frequently that travelers run out of funds. International tourism has multiplied these cases. When a tourist who had not taken enough money along or who dropped his wallet or was the victim of theft or robbery comes to the consulate asking for help, he will be told that the consulate is neither a bank nor a travel agency. But the consulate will give him advice how to transfer funds and how to contact relatives or friends. Only in exceptional cases will the consulate lend money, which has to be paid back. If a foreigner is involved in an accident or is a victim of an assault, his consul will take care of him and inform his relatives. If a catastrophe happens, if for example an aircraft crashes or a terrorist attack occurs, the consulate will try to find out whether some of its nationals were hurt and will set up a hotline for the relatives. When a severe crisis occurs, caused for example by a coup d'etat, the diplomatic or consular mission will attempt to protect its nationals. In such a situation, the consul is not left alone. All members of the mission staff will focus on managing the crisis. The Dutch Foreign Ministry has gone one step further. It has created a rapid deployment consular support team that consists of approximately 20 officials who can be called from their post anywhere in the world to assist Dutch citizens in case of a catastrophe. The first task in case of a crisis is to find out what is going on, whether the crisis will be quickly over or turns into a prolonged armed conflict. In such a situation, the exchange of information with other missions is helpful. These missions will also contact its nationals. This will be facilitated if the Council has an up-to-date list of his country's nationals residing in the host country. It is therefore a useful step if expatriates register with their mission. Some countries, such as the United Kingdom, provide a website that can be used to register contact details and travel plans online. By the way, Ukraine also has such a website. It is called in Ukrainian Druk and is deciphered as voluntary registration of Ukrainian citizens when traveling abroad. If the armed conflict continues, foreigners will gather on the premises of their embassy or consulate since this is a relatively safe place. Missions in countries that suffer from civil wars are better prepared to accommodate their nationals in times of a severe crisis. Unfortunately, kidnapping cases of foreigners occur frequently. These cases are challenging for consuls. The media report the kidnapping. The government of the offending country feels public pressure to free the hostage or hostages and passes the pressure on to its mission. The relatives of the kidnapped person also urge the consul to do his utmost. Since it is the task of the law enforcement authorities of the receiving country to cope with the crime, the consulate will focus on requesting the host government to investigate the case, find the hostages, and get them released unharmed. The consulate uses all its contacts to government officials who can be helpful and try to influence development to rescue the hostages. When 3 Indonesian seamen were abducted in the Philippines in May 2005, the Indonesian embassy in Manila not only contacted the foreign ministry but also the chief of army staff. Indonesia was convinced that the Philippine military could help to get the hostages released. Sometimes the kidnappers turn directly to the embassy or consulate to play it off against the host country's government. The consular officials may hesitate to enter into direct negotiations with the kidnappers since it is the responsibility of the host country to deal with the case. If the kidnappers are known and have put up demands for the release, the consulate may have a chance to mediate. After several Indonesians had been kidnapped in the Philippines in the summer of 2002, the Indonesian Consul General asked for the safe return of his compatriots, but left the decision on ransom payment to the Philippine government. Governments typically declare not to give in to the demands of the kidnappers and not to pay ransom, but they do not always stick to this policy. If the kidnapping is of a terrorist or political nature, the chances of the consulate to influence events are limited. Sometimes the victim or victims can be freed, sometimes all efforts of the consulate and the host government are in vain. The 1995 Kashmir kidnapping case had a tragic end. In July 1995, a group calling itself Al-Faran kidnapped 6 Western tourists, 2 Americans, 2 British, 1 German, and 1 Norwegian in the part of Kashmir that is controlled by India. One of the Americans escaped and the Norwegian was killed in August 1995. The kidnappers demanded that the Indian government should release a number of militants from Indian prisons in exchange for the lives of the kidnapped Westerns. Diplomats of the United States, the United Kingdom, Germany, and Norway intervened many times in New Delhi, and since Al-Faran had connections with a militant group based in Pakistan, also in Islamabad, asking the Indian and the Pakistani government to do everything within their power to find and save the hostages. Furthermore, they met anyone they could to influence the kidnappers to release the hostages. However, it was impossible to find the hostages and kidnappers. One militant who had been caught by Indian authorities claimed in May 1996 that the hostages had been killed in the middle of December of 1995. Unfortunately, the fate of the hostages was never solved. The ease of traveling has led to an increase of child abductions from one country to another. Foreign ministers of a number of countries, such as the United States, the United Kingdom, and Germany, offer information about what their missions abroad can do and cannot do for parents. In cooperation with the authorities of the host country, consuls can help to locate the child. In case the address of the child is known, American and British consuls offer welfare visits to the child. Of course, consuls cannot make rescue attempts. Cases of dual nationality are particularly difficult to solve. When the child has also the nationality of the host country, the authorities of the host country consider themselves responsible for the decisions concerning the child, and the consul has only very limited possibilities. The only existing international law mechanism is the Hague Convention on the Civil Aspects of International Child Abduction of 1980. The convention aims at the prompt return of children who were wrongfully removed to or retained in any state that is contracting party of the convention. Since 80 states are a party to the convention, there is often a good chance for a solution of a child abduction case. Persons who were detained in a foreign country are in particular need of assistance. It does not matter why they were detained. In most cases, they are in custody pending trial or imprisoned after trial. In the case a foreigner is detained, the interests of the receiving and the sentenced state collide. The receiving state claims jurisdiction over all persons on its territory, and the sentenced state wants to protect its nationals wherever they happen to be. In other words, territorial sovereignty and the national principle clash. Therefore, the Council needs to know what he can do. Article 36, paragraph 1, letter B and C of the Vienna Convention on Consular Relations sets out the rules. The Council has the right to visit and talk to a compatriot who has been arrested, imprisoned, or detained. There are many steps that a consul can take in favor of an arrested compatriot. He will try to find out the reason of the detention and discuss the legal and procedural issues involved. The arrested person will not be familiar with the peculiarities of the receiving country's legal system. Thus, information is crucial. The Council will provide the person in prison with a list of trustworthy lawyers from whom he can choose one. The Council will also see to it that from the beginning of questioning an interpreter is consulted if necessary. It is also helpful if the Council establishes a contact between the detained person and his relatives and friends. He will also check whether the detained person has been treated correctly. If the person in jail suffers from physical abuse, the Council will protest officially. If the food is insufficient, the Council will try to look for a remedy. If the trial is underway, the consulate has to decide whether an officer should attend. It may be helpful to demonstrate the sentenced state's interest in a fair trial. The Council can take these actions only if the arrested person does not oppose them, since Article 36, paragraph 1, letter C of the Vienna Convention on Consular Relations gives priority to the decision of the individual. The Council can only act on behalf of a detained person if he is aware of the citizen's predicament. He may have received the information from relatives and friends of the arrestee or from the media. Those who are best suited to pass on the information are the competent authorities of the receiving country. Article 36, paragraph 1, letter B of the Vienna Convention on Consular Relations, however, links their obligation to inform the Council to the wishes of the individual involved. The sequence of events is, according to the Vienna Convention on Consular Relations, as follows. The competent authorities are obliged to inform a foreign arrested person without delay that he has the right to request the assistance of his counsel. If he requests that the counsel be informed, the competent authorities have to do so without delay. Timely access of the counsel to the man or woman in jail is important. The solution of the Convention to make the decision whether to bring in the counsel depend on the jailed person's will is unsatisfactory because it can be misused. If a receiving government is unwilling to have the counsel involved, it can pretend that the arrested person did not request the counsel be informed. The counsel has no chance to prove the contrary. It is interesting to note that the United States has concluded bilateral consular agreements with more than 50 countries that require the notification of consular officials of the arrest of one of their nationals, regardless of the national's request. This is a far more satisfying way of dealing with the notification problem. It is a frequent task of consuls to assist detained citizens. The International Court of Justice had to interpret Article 36 of the Vienna Convention on Consular Relations in its judgment of the Legrand case rendered on June 27, 2001. Walter and Carl Legrand, two brothers, had attempted an armed bank robbery in Arizona, murdered the bank manager, and seriously injured another bank employee. On February 17, 1984, they were convicted of murder, attempted armed robbery, and kidnapping. On December 14, 1984, they were sentenced to death. Both brothers were Germans. They had come to the United States when they were still young children but had never changed their nationality. Before they were convicted and sentenced, the competent United States authorities never informed them of their right to consular assistance. The German Consulate General in Los Angeles was made aware of the case only in 1992, not by the US authorities but by the Legrand brothers. The German authorities made various interventions on behalf of the Legrands. The absence of the consular notification was raised in a letter dated on February 22, 1999, from the German Foreign Minister to the US Secretary of State. On 21st of December 1998, the Legrand brothers received formal notification from the US authorities of their right to consular assistance. Carl Legrand was executed in February 1999. Walter Legrand was executed in March 1999. in spite of a provisional measure order of the ICJ rendered on the same day and asking the US government to take all measures at its disposal to ensure that Walter Legrand is not executed pending the final decision in these proceedings. The case before the International Court of Justice was somewhat bizarre. According to the submission of the US government, the Legrand brothers had the demeanor and speech of Americans rather than Germans, and were not known to have spoken German. They had committed severe crimes and were convicted and sentenced in accordance with the laws of Arizona. The German government invoked the missing of the consular notification very late, only 2 days before the scheduled execution of Karl Legrand. In February 2000, the United States government apologized to the German government for not promptly informing the Legrands of their rights of consular representation. It also made known that the US authorities were trying to strengthen the regime of consular notification. When the court rendered its decision, it could not be of any help for the Legrands since they had been executed more than 2 years ago. The German side justified its action by arguing that it wanted to get a confirmation of the right to consular assistance by the ICJ in order to prevent a repetition of such cases. The judgment was, therefore, of a theoretical nature. The court determined that Article 36, paragraph 1, letter C, establishes an individual right of the detained person to be informed about the possibility to request consular assistance. Consequently, the court found that by not informing the Legrand brothers of their rights to contact the consul, the US government violated obligations toward Germany and the two imprisoned persons. Since Germany was not informed in a timely fashion, it was prevented from rendering the assistance provided for in Article 36, paragraph 1, letter A and C. Thus, also these provisions were violated. Since a review and reconsideration of the convictions and sentences were not permitted after the violation of Article 36, paragraph 1 had been established, also Article 36, paragraph 2 was violated. This provision obliges states to give full effect to the purposes for which the rights accorded under this article are intended. Now let's talk about administrative duties of the consuls. According to Article 5, letter D, it belongs to the functions of a consul to issue passports and travel documents to nationals of the sending state and visas or appropriate documents to persons wishing to travel to the sending state. The passport is the traveler's indispensable companion. It is first of all evidence of the traveler's nationality. The nationality on its part determines the rules for the entry into or the departure from a foreign country. Passports are checked everywhere upon entering a country and often also on departure. All countries have passport laws laying down the rules, for example, the form of application, the requirements for issuing or denying a passport, the format to be used, and the period of validity. Many states try to make a passport difficult to forge by writing all important data on a laminated page, by using the photo-digitalized imaging system, and by adding biometric data. The various municipal laws differ. Most consuls are authorized to issue passports to nationals who have their residence in the consular district and to those traveling nationals whose passports have been lost or stolen. For example, United States consuls are only authorized to issue passports that are needed for urgent travel. All other US passports are issued by the Department of State. Many consulates are more burdened with issuing visas. Some figures may demonstrate the strain for missions. In 2012, the German embassy in Kiev received approximately 131,000 visa applications, of which 118,000 were granted. A visa today is mostly a permit to enter a foreign country and to stay there temporarily or continuously. It is fixed in the form of a document to a foreigner's passport. Visas are given for various purposes, for example, to transit a country, to stay there temporarily as a tourist, to visit relatives, to do business, to participate in sports events, to study or to teach, to work, or to become a citizen of the receiving country. Every country has its own policy for regulating entry and residence of foreigners. The work of the consulate is to find out whether an applicant fulfills the requirement under which a visa can be granted or whether his stay is undesirable. It is the consulate's duty to fight irregular immigration. Undesirable are those foreigners who may become a burden on the public budget of the receiving country. Their stay violates the national interest. Thus, the consul defends his country's interests when he decides about issuing or denying a visa. The general idea is expressed in Article 3, paragraph 2 of the German consular law that states, when fulfilling their duties, the consular officers have to protect and promote the reputation and interest of the Federal Republic of Germany to the best of their abilities. The task for the consul is challenging since he is often confronted with forgery, lies and pressure. If an applicant claims that he or she wants to visit the consul's country for business reasons, the consul will check whether the applicant conducts the business at home, whether he has ever been abroad, has a banking account, is a member of the Chamber of Commerce and Industry or of another business organization. If an applicant claims he wants to visit the consul's country, as most of those do who have the intention to stay there, the consul will focus on ascertaining whether the applicant will return. He will check whether the applicant has a return ticket, carries along enough money for the intended length of his stay abroad, or has a sincere invitation, and whether he can give sufficient reasons why he is interested in visiting the consul's country. In many places, consuls of Western countries get together regularly to exchange information to cope with the latest tricks of applicants. The European countries, which are members of the Schengen Treaty, have abolished internal border checkpoints and controls. When a person wants to travel, for example, from France to Belgium, he or she crosses the border without being stopped or checked. At the same time, these countries created a single external border with immigration checks for the Schengen area. Any third country national who has a visa for one of the Schengen countries may enter any other without checks. A common model for visas, a common list of countries whose nationals need visas for the Schengen area, a Schengen information system, and a common visa policy were created. For consuls of Schengen countries in third states, the new system meant close cooperation and many joint meetings. Many goals are to be achieved. For example, all consulates of Schengen member countries must apply the same criteria when deciding about a visa application. Multiple application must be discouraged. Information about attempts of fraud must be exchanged. The system is not perfect and a number of reforms have been introduced. Various solutions are possible to achieve an unified practice. At some or every post, the consulate of one Schengen country alone issues visas for the Schengen area. This has been proposed by France. Or the visa sections of all Schengen countries at a post are merged and the head of this agency makes the final decision on an application. Since consular activities are based on municipal law, European Union member states are reluctant to transfer the necessary authorization to other officials than their own consuls. Also in future, cooperation among European Union member states in the field of visas will be characterized by intergovernmentalism and not by supranationalism. Now we will discuss consular functions, which are more of a legal character or linked to the administration of justice. These functions are listed in letter F, G, H, I, and J of Article 5 of the Vienna Convention on Consular Relations. Consuls can act as notary and civil registrar. Consuls everywhere in the world perform simple certifications of signatures and copies. They also authenticate or legalize official documents of the host country, for example, birth and marriage certificates that can be used afterwards in the consul's country. Letter F of Article 5 of the Vienna Convention on Consular Relations insists that consuls can act as a notary and civil register only if it is not against the law of the receiving country. What the provision does not mention, but what is equally important, is that the consul can perform these functions only to the extent that is sanctioned by the legal system of the sending state. Legal systems differ in defining the power of a notary. The legal systems of the Romano-Germanic family of civil law empower a notary to establish an official document with the result that such a document is supposed to be authentic. The notary is responsible that the legality of the act is strictly kept. According to paragraph 10 of the German consular law, a German consul, for example, may set up an instrument for a purchase and sale contract of real estate, for a testament, for a marriage contract, for consent to an adoption, or for an application for a certificate of inheritance. Common law systems grant a notary far less authority and do not burden him with guaranteeing the legality of the act. If a citizen of the sending country dies in the receiving country, the consul will try to inform the deceased relatives and to assist in the repatriation of the remains. Article 5, letter G, authorizes the consul to safeguard the deceased estate in the interest of their heirs. In doing so, it is particularly important to respect the laws of the receiving state because most states have laws regulating inheritance cases of foreigners. Though these laws and regulations vary considerably, they often provide that a domestic agency takes care of the estate. Thus, the estate functions of consuls have shrunk. It seldom happens that a consul makes use of the authorization of letter H of the Article 5 of the Vienna Convention on Consular Relations by applying for guardianship or a trusteeship for a minor or a mentally disturbed person. However, consuls frequently render assistance to mentally disturbed citizens. By empowering consuls to serve legal process and to take evidence, the Vienna Convention on Consular Relations, its Article 5, letter J, gives them judicial functions. To examine witnesses is in most legal systems the prerogative of judges. Some countries are therefore reluctant to make use of the possibilities offered by letter J of Article 5 of the Vienna Convention on Consular Relations to authorize their consuls to take evidence for their courts. For example, Canada doesn't give that authorization to its consuls. Other countries, like Germany, for example, to give such an authorization, however, only to those consular officers who have either passed the examination to be a judge or have the necessary training and experience. Since the consul has no means of coercion at his disposal, he depends on the willingness of the witness to make a deposition. Since he is requested by Article 5, letter J of the Vienna Convention on Consular Relations to respect the laws and regulations of the receiving state, the consul cannot examine the witness if a host country, like for example Switzerland, does not allow it. The next consular function is connected with shipping and aviation issues. The ports around the Mediterranean were the places that were early on visited by foreign businessmen who often settled there. They became the first places in need of assistance by consuls. Shipping issues were instrumental in bringing the first consular relations into existence. A collection of maritime ordinances from 1279 authorized consuls to accompany vessels. When international commerce expanded, shipping matters became very much the core activity of consulates located in harbor cities. During the last several decades, maritime functions of consulates have shrunk considerably. Various reasons are responsible for this development. Vessels no longer stay days or weeks in a harbor. Since the technology of loading and unloading a vessel is fairly advanced, a ship will stay for only a couple of hours in a harbor. The agent of the vessel's shipping company deals with the necessary paperwork and negotiations with local authorities. The International Maritime Organization is promoting cooperation among member states effectively. The workload of consuls of some of the great shipping countries was tremendously reduced when their vessels began to register under flags of countries where costs, particular salaries for the crews, are less expensive or where tax benefits can be enjoyed. The many consular functions with regard to vessels and crews mentioned in Article 5, litera K and L of the Vienna Convention on Consular Relations are supplemented by municipal and international law. The Council's cooperation is still important in case of an accident during the voyage of a vessel. Methods of how to deal with accidents, however, differ. For example, the German law and practice authorize the Council to take evidence of a maritime accident. To assist seamen continues to be an important task of councils. Their functions vary according to the different national regulations. Main functions include supervising the signing of the employment contracts by a seaman and his discharge, taking care of seamen in distress, and of their repatriation. In all of such cases, the councils are guided by their own laws and regulations, and, if existing, by international treaties. Article 5, litera K and L of the Vienna Convention on Consular Relations entrusts Council with the same powers with regard to aircraft that it gives them with regard to vessels. Councils, however, seldom have to deal with aviation issues because they are, as the Canadian Manual of International Air Carriage rightly suggests, complex matters. The International Civil Aviation Organization and many international bilateral and multilateral treaties deal with these matters. Now let's move to our next question. It is consular privileges and immunities. The Vienna Convention on Consular Relations grants a consul less privileges and immunities than the Vienna Convention on Diplomatic Relations allows a diplomat. As has previously been explained, diplomatic inviolability has two aspects. Diplomats enjoy protection by the receiving state and they are free from coercion from that state. Article 40 of the Vienna Convention on Consular Relations gives a consul literally the same protection that is enjoyed by a diplomat. A consul is also generally free from coercion, that is, he is not liable to arrest or detention. However, Article 41, paragraph 1 of the Vienna Convention on Consular Relations makes an exception. In the case of a grave crime, the consul can be arrested, indicted, tried, and sentenced. If other criminal proceedings are instituted against him, they must be conducted in a manner that allows the consul to perform his functions. While the diplomat enjoys comprehensive inviolability, the consul enjoys only limited inviolability. Diplomats and consuls are given privileges and immunities with regard to their function, as is stated in the preambles of both conventions. Since the conventions accord a consul a lesser degree of inviolability than a diplomat, a consul is considered to have a lesser rank than a diplomat. Consequently, in the preamble of the Vienna Convention on Consular Relations, the formula of the Vienna Convention on Diplomatic Relations, the diplomats act as representing states, is substituted by the wording that consuls act on behalf of their respective state. Consuls, however, do represent their states in their districts. As has previously been shown, consuls are entitled to do almost the same type of work that embassies do. Besides specific consular questions, they handle, among others, political, commercial, and public relations issues. Therefore, consulates are organized like embassies. However, a consul working at a consular post enjoys a lesser degree of inviolability than his colleagues working in the consular section of an embassy who is accorded full diplomatic immunity. It is Article 70, paragraph 4 of the Vienna Convention on Consular Relations. This difference is due to the separate histories of both institutions. Consular institutions developed independent of diplomatic relations, as was previously mentioned. Consuls had originally no representative functions towards the host state. To a certain extent, this historical background continues to have an effect. In practice, arrests and trials of consuls seldom occur. Consular officers enjoy less personal immunity than diplomatic agents. A diplomat is granted total exemption from the civil and administrative jurisdiction of the host state, except in cases related to his real estate in the host country, to succession, and to his commercial activities. It is Article 31 of the Vienna Convention on Diplomatic Relations. A consul is free from the host country's jurisdiction only in respect of acts performed in the exercise of consular functions. It is Article 43, paragraph 1 of the Vienna Convention on Consular Relations. Contract issues and accidents are defined as private acts. The restrictions imposed on a consul's immunity are vague because the term consular functions is not defined by the Vienna Convention on Consular Relations and thus open to interpretation by sending and receiving states and finally by their courts. Many and different decisions have been proclaimed by courts of many countries. As privileges, that is, exemptions from laws of the host country, are concerned, consuls are approximately on par with diplomats. It is obvious that consuls, like diplomats, must be exempted from personal services and from the social security system in the receiving state. Consuls enjoy the same exceptions from direct taxation that are granted to diplomats. Imports for the consul's personal use are free from customs and duties. There is a slight difference from the corresponding provision of the Vienna Convention on Diplomatic Relations, inasmuch as the Vienna Convention on Consular Relations restricts the volume of the import to the quantities necessary for direct utilization by the consul. The same reasonable idea should apply to the imports of diplomats. The members of the supporting staff, called in the terminology of the Vienna Convention on Consular Relations the consular employees, enjoy fewer immunities and privileges than their colleagues working in embassies. This is unsatisfactory because the members of the supporting staff are moved from embassies to consulates and vice versa during their career and perform exactly the same functions whether they work in an embassy or in a consulate. Consulate employees are not even granted the restricted inviolability accorded to consular officers by Article 40 and 41. Consular employees are only given functional immunity from the host country's criminal, civil, and administrative jurisdiction. Thus, they enjoy immunity from the receiving country's jurisdiction only for activities that are closely linked to their work. It is understood that the home-based consular employees are exempt from the host country's social security provisions and personal services. They enjoy the same exception from taxes that are granted to consuls, but are given exemption from customs duties only for imports in respect of articles imported at the time of first installation. That the service staff is only granted exemption from the social security system and from taxes on their wages if they are home-based is reasonable. In most cases, the service staff is composed of locally employed nationals of the receiving state who are subject to the host state's laws and regulations. Now we will talk about the privileges and immunities of a consular post. Exactly like the term diplomatic mission or embassy, the term consular post or consulate denotes either a group of people or a building complex. Article 1, paragraph 1, letter J of the Vienna Convention on Consular Relations defines consular premises as the buildings or parts of buildings and the land ancillary thereto, irrespective of ownership, used exclusively for the purposes of the consular post. With this wording, the intention to grant fewer immunities and privileges to consulates than to embassies is continued. The residence of the consuls, not to mention the residences of the consulate staff, are not included, with the consequence that they do not enjoy any inviolability. The consular offices have to be separated from offices of other institutions, for example from the rooms of the Cultural Institute installed in the same building. Function and meeting rooms for nationals of the sender state who work in the receiving state and are not used exclusively for consular purposes thus do not enjoy any inviolability. A battle was fought during the Vienna Conference over the scope of the inviolability that was to be granted consular premises. A compromise was reached, giving consulates only limited inviolability. The view was still prevalent that consulates were less representative of their governments than embassies. As in the case of the personal inviolability of consular officers, the inviolability of consular premises has two main aspects. Consular premises have to be free from interference and have to be protected by the host country. Article 31 of the Vienna Convention on Consular Relations states that consular premises shall be inviolable to the extent provided in this article. The authorities of the receiving state shall not enter that part of the consular premises which is used exclusively for the purpose of the work of the consular post, except with the consent of the head of the consular post or of his designee or of the head of the diplomatic mission of the sending state. But the consent of the head of the consular post may, however, be assumed in case of fire or other disaster requiring prompt protective action. As we can see, Article 31 of the Vienna Convention on Consular Relations does not grant consulates comprehensive inviolability. Agents of the receiving states are forbidden to enter the premises of the consular post without the consent of the head of that post. In case of a fire or disaster, however, the consul's consent may be assumed as has already been discussed. Another exemption from the inviolability of consular premises is made by not prohibiting such attachment or execution in a consulate, as does Article 22, paragraph 3 of the Vienna Convention on Diplomatic Relations. Only requisition is prohibited by Article 31, paragraph 4 of the Vienna Convention on Consular Relations. Thus, consular premises are not completely free from the receiving country's coercive legal measures. As far as protection is concerned, consulates enjoy the same status as embassies. It is a special duty of the receiving state to take all appropriate steps to protect consular premises. The government of the receiving country is under obligation to do more than just to maintain law and order. The immunity that is granted to a consular premises finds its counterpart in the prohibition to misuse a consulate's premises. Archives and documents of a consulate enjoy literally the same inviolability as those of an embassy for historical reasons. Even those countries that were not willing to accept the inviolability of consular premises recognize the inviolability of consular archives. Both conventions give archives and documents of consulates and embassies comprehensive inviolability in order to guarantee the consulates and embassies' ability to function. Consulates can fulfill their tasks only if they can freely communicate with their customers, the host government, and their superiors at home. The Consular Convention grants consular posts freedom of communication. The wording of Article 35 of the Vienna Convention on Consular Relations follows the text of Article 27 of the Vienna Convention on Diplomatic Relations. Some differences, however, are worthwhile mentioning. Paragraph 3 of Article 35 of the Vienna Convention on Consular Relations lays down the challenge and return principle. If the host government has reasons to believe that the pledge contains something other than official papers, it can insist that the bag be opened in the presence of representatives of the sending state. In case that request is rejected, the bag has to be returned to its place of origin. It is crucial to note that under no circumstances may a pledge be opened against the sending country's will. This procedure was followed when, on 7th of March 1989, drug-sniffing dogs drew attention to a French consular pledge that was in transit at Miami airport. The United States authorities asked French consulate personnel to open the bag. Since the French official declined to do so, the bag was returned to Paris. Consuls can do an efficient job only if they have access to the competent authority of the host country. Their partners are regularly the local authorities and only in exceptional cases the central authorities. Article 38 of the Vienna Convention on Consular Relations guarantees free access to these authorities. This guarantee is not of much help in practice. It depends on the skills of the members of the consulate and on the willingness of the local officials whether successful contacts are established. If a problem cannot be solved at the local level, the Council will suggest that the embassy take up the case with the central government. So, this was the main information concerning the topic of our today's lecture. Thank you for your attention.